I would like to introduce to my subscribers a new series on my channel that I am calling
Bond. James Bond.
Your name, sir?
Ozahana.
Thank you.
At this time, Your Honor, I'll be requesting adjournment to obtain and review media discovery with Mr. Hyman. I would also like to address Bond if when appropriate.
Master Bond.
Yes, Your Honor. Talking to Mr. Hyman making me request a release on a tether. Mr. Hyman would be able to release to his father's address. He currently helps his father in taking care of him because his father does have some mobility issues after a car accident. Mr. Hyman has been consistently working. So at this time, I'd like to request a release on a PR bond, tether, or in the alternative, a reduction in the bond.
Response.
Rather than people opposed to the reduction in bond, we originally requested 100,000. We're giving 50,000 for 10%. In this case, the difference had broken up, and he was at the victim's residence. Was all much in the car. They got into an argument. He slammed the victim to the ground, pinned her by the chest. Get away from the defendant, go in her house, and lock the door. He kicked the door, and the deadbolt was still locked, and they continued to argue. He then went and retrieved a shotgun, said, "I got something for you," and cocked a gun, and completely denied this at arraignment. So people have concerns about public safety and would ask the court not to respond.
Anything else?
I was able to speak to Mr. Hyman's father, who is here this morning. He says he would be responsible for Mr. Hyman, and he has that support. So I would still request a reduction in bond.
Well, given the court does consider him a danger to the public, motion for bond reduction denied. Bond continues.
This is Mr. Orr, Your Honor.
It is. Has been for the last 5 minutes he's been sitting. Mr. Bukovich's case?
Yes, Your Honor, it is. Oh, he's coming up right now.
Public Defender Fellow Nicholas Bukovich on behalf of Mr. Orr.
Mr. Orr, can you state your name, please? Jason Orr. Thank you.
At this time, Your Honor, I'll be requesting a preliminary exam date. To our knowledge, discovery is. I would also be addressing bond when appropriate.
That's the bond.
As to bond, yes, Your Honor. After speaking with Mr. Orr, he would like me to request a release on tether to his mother's address in Suzanne Court in Inkster, Michigan. He's currently working on getting licensure for such things as HVAC and pool maintenance. He has a couple more classes to complete. He's been unable to complete these classes due to being in custody. So he would like to be able to go out, be released, complete these classes, and be able to begin work in this field. So I'll be asking for a release on tether or, in the alternative, a reduction in bonds.
Response.
He gets pulled out of Oakland County for an OWI, in which the bond is $7,500. He also has a previous ED conviction from 2010 and other controlled substances and high VAC. He also, in this case, the victim and defendant were arguing. He grabbed her by the hair and neck. She tried to break free, her to the ground. He strangled her and let go. He found out the police were called. The police were called by their daughter when she heard the victim scream for her to call the police. And their son had to step in to stop the assault. He also threatened to kill the victim numerous times that day of the assault, as well as during the assault that was also heard by their daughter. So we would object to any reduction in bond.
Anything else?
That is this time, Your Honor.
Motion for bond reduction denied. Bond. Court calls case People versus Thomas Rascal.
Absolutely, for the people.
Mr. Rascal, who's appearing to my right. Could you please state your name for the record?
Thomas Rascal.
And my client would like to address bond.
Go ahead.
Your Honor, the reason for my client, he is actually a perfect candidate and a great candidate for sobriety court, but because of matters outside of this jurisdiction, older matters outside of this jurisdiction, he was not accepted into our sobriety court. My client wants to fight the warrant that brought him here. He wants to fight it. He gave me a backstory behind that. My client is not actually a threat to the community. He will be here for every court appearance the court wants him to be here for. He just has a substance abuse problem. He is willing to be released into treatment if the court is inclined to do so. He was homeless. He just got a home. He's back in a home now. He has animals that he needs to take care of in that home. He's willing to be tethered there, Your Honor. We honestly thought that sobriety court was going to work for him.
Well, the problem is there's nothing in place and he's already violated the conditions of his bond previously, right?
Your Honor, my client give me the judge. Your Honor, my client, as far as, and I went over the bond violations with him. He's indicated that he has a medical marijuana card. And so, there is that. If you are telling him that he can't smoke that, even with that.
I'm not saying, he admitted to the violation.
Your Honor.
Your Honor. Okay. Your Honor, my client, again, he just has a substance abuse problem. If the court.
I understand that,
If the
but
treatment, he's fine with that.
just Londy.
Your Honor, the difficulty is at the time of this case, when the defendant was stopped, it's my understanding that because he had a no bond bench warrant for a felony CCW out of Lafayette Village, so it's not just a substance abuse problem that seems to be going on here. There seems to be tangential things that are very concerning to the public. And we do have the issue with violations here. I also show currently in X jail, we have 2 out-of-county holds. One for Battle Creek with a $200 bond for retail fraud, one out of Lansing for another retail fraud case for $868 bond. So the concern here is that if there is a PR, it's not going to be released. Likely they will go to a different location or several locations in the state. I'm asking the court to continue the bond. I haven't seen the denial, so I haven't seen why he didn't get in treatment in court. But if it is as represented, I'm sure it will be, absolutely. As defense counsel saying, it's because of his other cases throughout the state. So that concerns the people and his ability to remain law-abiding bondholders.
Your Honor, he has no holds. I checked into it. There's no, according to X jail, he is not being held for the CCW charge. They're not looking for him.
She's going to show you the holds
for
before you make that representation to the
He
court.
has the two smaller ones, but not for the CCW.
Oh, 2 small holds.
I meant to say not
Those are,
for CCW, Your Honor.
those, because they're small, they're not holds.
Yes.
Okay.
And they're really, really old charges, Your Honor, and my client wants to address those as well.
I know, because he didn't go take care of them. That's why they're old.
I
I was
understand.
in prison.
Thank you. Your Honor, we would just like to ask to be allowed out of bond.
Motion for bond reduction is denied. Bond will continue. Thank you.
You, Francisco de Jesus Guerrero Gonzalez. Sir, you are wanted out of Maricopa, Arizona. I want you to know that you're not here alone. Your lawyer's here with you, but she is on Zoom at this point. Your lawyer is asking me to set you a bond, but I don't know. I don't know anything about you, and I have to get to know you in a very short period of time. The way we do that is by looking how you are on paper, because that tells me a lot of who you are, what you wanted, and your prior criminal history. So, Dave, tell me about Mr. Guerrero.
Your Honor, he's wanted for 4 counts of exploitation of a minor, dangerous crimes against children, class felony 2. I spoke with Maricopa County Attorney's Office, and they state that they don't oppose him getting a bond, surprisingly. However, I have some reservations. I spoke with Pari about this. Is at the time he was arrested, is that he had an open flight to Mexico, and so regarding the severity of the charge and his ability to obviously leave the jurisdiction of America, is that I'd have reservations regarding his.
Well, we can always make him surrender a passport.
And that's what Pari was saying is him surrendering.
And I do have an update on that day, and I apologize for not telling you earlier about it. I can tell you now in front of the judge, but whenever you're done, I'll let you know.
No, I mean, that's if you want to.
Oh, okay. So yeah, Judge, here's the thing. I think the reason that jurisdiction's not opposed is because he's been under investigation for 2 years for this. And in fact, he already has an attorney there that I've spoken to. So normally in these scenarios, when you're working so closely with the jurisdiction, the times that I've done it here in Houston, out of consideration for the client and the attorney, normally when they end up filing the warrants, they let the attorney know. That's the reason that you get an attorney preemptively in the first place. I don't know why that didn't happen, but there's absolutely no reason to think he's not going to turn himself in. He's 25 years old with no criminal history. He went to college in Arizona State. Judge, when he graduated, he stayed there, and he worked as the press secretary for the Mexican consulate. The reason he had the ticket, and I wanted to verify before telling you, is it was already booked. It was a round trip ticket. The ticket back to Mexico was set for yesterday. He would never buy a ticket while he's in custody to go to Mexico.
Was this a 2B or was this already an open charge?
No. It was, they literally just filed the warrant. He has been under investigation for 2 years. They just filed the warrant. And for some reason, they didn't tell the attorney he was working with so that he could set up a time to turn himself in, which they usually do. In fact, when she found out about it, she called when she found out he was in custody, and that jurisdiction told the attorney, her name is Melanie, that the charge is still unfiled. So I don't know where the misunderstanding came, but the warrant was literally just filed. If he knew about it, there was no way.
There's no misunderstanding. They're just, he had a flight, but they filed the case in between.
Right.
Exactly. So, and just so you know, Judge, so he got picked up on the flight in. Like, he came to the US on Thursday. He was set to go back to Mexico Sunday. And the reason for that, just so you know, is because just so you know, his mom lives in America. His stepdad is an ER physician. He's going to be staying with them. He will surrender his passport. But when he didn't know this was all going on, his biological father has 7 bakeries in Mexico. So he was helping his dad that's why he was in Mexico. But he has no issue staying here. He has family here. He has ties here. He already has an attorney. So
Aria, we're good. We're good. Are you okay?
I mean, the demanding jurisdiction is okay with it.
You're right.
Like I said, I just have reservations regarding the severity of the charge. I understand what Claudia is saying, but if the demand jurisdiction is open for a bond, I just defer to the court regarding setting a bond.
Also, about the charges, one more thing about the charges. They read way worse than they are. I'm not saying it's an okay charge. I just am telling you that I spoke to the attorney, and that's the way they word possession of child pornography. I just want the court to know that this is not a case where there's actual 4 victims. That's their version of possession.
So I for me at least, I want surrender of the passport.
100%.
And then we'll set a bond.
Would someone be here to surrender that now to the clerk's office, or?
Let me ask him where it is, and I can have someone there, because I don't know where his passport
So
physically
let's
is.
do this. I'll have him put back and you can talk to him in the back.
Okay.
Let's figure out the logistics and then we can come back and set the bond. But I'm not going to set it until I know it's been surrendered. Someone else has possession of it, and then we can set the bond for you. I mean, I'm okay with it if you are, and Paria obviously is, right? Just we need to figure out what the amount is, but first things first is the surrender of the passport, and then we go from there.
Do you want me to stand down? Do you want to reapproach today, or do you want to?
No, we'll reapproach today. Let me talk to him about where it is. It may be in his property if he was stopped at the airport. So let me figure that out, and I'll reapproach.
All right.
Okay, I'll be quick. Bye.
25,000 a day? She wants 10,000?
Yes.
So we'll split the puppy.
Okay.
15.
15? Yes, Judge.
15,000.
Yeah, but I'm not setting it yet. Understand that once you guys surrender the passport, I can set you a bond, and I want you to understand that we take this absolutely serious. We give you 2 weeks from the date of your release to go surrender yourself or post bond in Arizona. You're old enough to understand that actions have consequences. If you fail to do this, I will revoke this bond. You're going to be out all that money. I will issue a nationwide warrant for your arrest, and I'm going to get you. And this time, I won't do this again. You get one opportunity, and if you fail to go do it, we set bond at 0, and the next time I will hold you until Arizona comes and gets you. Do you understand?
Yes, Your Honor.
Okay, so we'll set you for tomorrow to wait for the passport, and then we'll go from there.
Call the case of the people versus Gerald Childs.
And good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Childs. And then say your name, please. Gerald Childs.
Thank you.
Remember, today is a time and date set for the probable cause conference, and it is my understanding that it's going to be a waiver. I've been in touch with Mr. Bernstein, and we've been talking about a resolution that will include count 1, sexual conduct in the first degree, count 2, the GBH, count 3, the FTD, and count 4, the larceny from a person. We do not have an agreement at this time. So the waiver will be on those 4 counts with an added count 5 of criminal sexual conduct in the first degree and an added count 6 of criminal sexual conduct in the first degree. It's a multiple variable. It'll read exactly as count one, that the defendant did engage in sexual penetration with Audrey Sharon under the following circumstances during the commission of the felony of assault by strangulation, and or defendant aided and abetted one another in effective sexual penetration through force or coercion, and or defendant effective sexual penetration through force or coercion, and the victim sustained personal injury with the same penalty, life offense.
So he's going to be bound over on 6 counts.
That's right.
Is that correct? And, all right, very good.
And if the case does proceed to trial, it would be on all 6 counts. We will not remand for a preliminary exam, but the plea negotiations will involve counts 1 through 4. If we don't reach a plea and go to trial, it will be on 1, 2, 3, 4, 5, and 6.
That's your understanding, Mr. Birch?
Yes, Your Honor. We have the raw workings of it. It'll eventually be a plea involving just like 1 count. The 2 additional counts will be dismissed later. If we go to trial, they will be pressed, though. So we understand that.
All right. You understand that those are life offenses, sir? Yes. All right.
Thank you.
We understand and waive any further reading, Your Honor. Mr. Child stands mute, and sure Ms. Reiser will send me an amended information.
Pending and waiting for more reading, standing mute to all 6 counts. Court will enter a not guilty plea. Pretrial will be set for. Bond, as denied, will continue.
Thank you, Your Honor.
Versus Brady Peterson.
Morning, Your Honor. James Fifelski, standing in for counsel of record on behalf of Mr. Peterson. State your name, please, sir.
Brady Peterson. You have any objection to Mr. Fifelski standing in?
No.
All right, thank you.
Your Honor, we would like to keep this on for a preliminary exam at the next
Is
available
all
date.
discovery complete?
I believe it is, Your Honor. Also like to argue bond if I could.
As to bond.
Your Honor, as to bond, it's my understanding bond is currently set at $150,000 cash, maybe surety. It seems pretty high given the fact that these are 10-year felonies. My understanding is that Mr. Peterson does not have any adult felony convictions. He has been gainfully employed at Blue Star Demolition in Macomb County, where essentially he has been raised in Macomb County. So minimal contacts in Washtenaw County. Understand he has not had any contact with the complaining witness since October 15th and has had no reason to. They broke up. They haven't had any communications. So he really has no reason to be in this county but for the court proceedings, and otherwise has a resident with his aunt, I believe. Yes.
In Clinton Township that he'd be able to either be tethered to or home confinement with work. Some way, Your Honor, that I believe assure the court that though he won't have any contact with the complaining witness and he will continue to appear for court proceedings. And lastly, he also has 2 children. One is a stepson that he has joint custody over, cares for him back at home in Clinton Township. He also has a 6-year-old son who passed away last year unexpectedly from a rare heart disease. So I think he is a good-hearted family man that will take these court proceedings seriously. Just ask for a significant bond reduction so that he can post something reasonable.
Respond.
So we requested 250,000 cash or surety. I understand that it was set at 150,000 cash or surety in this matter, but that's still lower than what we asked for. There were 2 counts of strangulation because, to our knowledge, there were 2 counts of strangulation that occurred over a time span. The defendant also has 3 holds, one out of Buena Vista Township for $15,000, a hold out of Davidson Township for $100, and a hold out of Clinton Township for $10,000, 10%. He has a lengthy criminal history dating back to 2010 with a juvenile adjudication for armed robbery. He also has 2 convictions for DD second and R&O, and interfering with a crime report, maluse, obstruction by disguise, as well as numerous dismissed DVs. In this particular case, the police were contacted for a welfare check by the victim's mom, because despite the fact that the victim and the defendant were broken up, the defendant had been sending out sexually explicit material of the victim to other parties, including the victim's mother. When law enforcement contacted the victim, it was only then that she disclosed these acts of violence that occurred over the span of 2 months. These particular incidents are 10-year felonies, but they are rather severe strangulations. The victim in one incident described the strangulation by being lifted off of the ground by the neck with both hands. She ended up on her back on the floor where she continued to be strangled to the point of almost losing consciousness, describing it as if she was seeing stars. She had photos documenting this with large bruising on both sides of her neck, consistent with fingers ripping. The fact that there was continued conduct after the breakup makes me concerned that the fact that they're separated is not the conclusion of this and is not the end of the threat that this to the victim. I don't think that any reduction below $150,000 at this time is appropriate.
I would just respond by stating something like a tether or even home confinement in Macomb County, which is at least an hour away from Washtenaw County, would be significant to protect not only the complaining witness, but the community. And I don't think otherwise, with strong community ties in Macomb County, my client is a flight risk to fail to his obligations to this court. The details of the case can be dealt with at preliminary exam, and I can't speak to that other than the fact that I think $150,000 is excessive given the fact that these are not capital or more serious felony offenses.
Motion for bond reduction is denied. Court believes the bond is set as is appropriate.
Thank you all for staying to the end. I do hope you liked.
Bond, James Bond.
If so, please subscribe, and Bond and I shall see you next time. If you'd like to see a really cool judge take apart a criminal, please click on the episode on screen now.